Hello, my name is Abe Mashney, criminal defense attorney here in Lexington, Kentucky. Today's topic is you've been charged with a criminal offense. Now what? I'm going to run through what you need to know about the process leading up to and during your initial appearance before the magistrate judge. Before the initial appearance, you'll usually meet with your pre-appointed attorney and a U.S. probation officer to go over a financial affidavit. Here in the Eastern District of Kentucky, we don't have a federal public defender's office. Instead, we have a panel of attorneys called the Criminal Justice Act, or CJA panel, and that they are selected by the federal judges. Once you complete the financial affidavit, the magistrate judge will determine whether or not you qualify for a CJA attorney. And even though you've qualified or been appointed or pre-appointed, you always have the right to hire your own counsel. I'm a member of the panel, but I also take cases privately as well. So at your initial appearance, the magistrate judge is going to inform you of your constitutional rights, such as your right to remain silent and your right to counsel. Magistrate judge will inform you the charges and the statutory maximum penalties each charge carries. The magistrate judge will then ask your attorney if they have reviewed the criminal complaint or indictment with you, the client, and if the attorney believes that the client understands the document and whether or not the client's name is spelled correctly on the charging document. If the client is before the court on a criminal complaint, meaning that the government has just charged them and not indicted them yet, the magistrate judge will ask the defendant if he wants a preliminary hearing. This is a hearing where the judge has to determine probable cause. Now, probable cause is a very low standard. However, it does provide some insight into the background and the investigation. It also can set you up for suppression issues down the road. If the client is before the court on an indictment, the defendant is not entitled to a preliminary hearing. If the government wants the client detained, which here in the Eastern District of Kentucky, they almost always do, the prosecutor will move at the initial appearance for detention. This will be controlled by the Bail Reform Act, 18 U.S.C. 3141. In most instances, the detention hearing is scheduled at a later date, usually about 3 to 5 days, to get witnesses prepared and present. Prior to the detention hearing, U.S. probation officer will conduct a bond interview. And in this bond interview, there'll be discussed criminal history, mental health, substance abuse, physical health, family, financials, residential questions. It is very, very important that you are 100% honest during this interview because it can have major implications during the sentencing. For instance, if you say one thing during the bond report and then you say a different thing in the pre-sentence report, that's going to cause you big problems. At the detention hearing, the magistrate judge must determine whether or not there's any conditions of bond reasonably to assure the defendant is not a flight risk or a danger to the community. Hope this has been helpful. If you or a loved one is facing a federal investigation or charge, please feel free to give us a call at 859-259-0727. Again, my name is Abe Mashney, and as always, thanks for watching.